Good morning, sir. And I see Ms. Tolman. Good morning, ma'am. All right, so Mr. Silverfield, you are the appellant's counsel here, and we're ready to proceed with your argument. Let us know how much time, if you wish to reserve for rebuttal. And you are excellent.
May it please the court, this is John Silverfield on behalf of the plaintiff appellant Lafindo General Services DBA Pool and Deck Concepts, pursuant to a request for oral argument filed by the defendant appellee FBR Marble Inc. in this matter. If it may please the court, I would like to reserve 4 minutes for rebuttal.
Very good, sir.
Your Honor, this is an appeal of an order granting judgment on the pleadings, which the standard of review here is de novo. The court's analysis is thus limited to whether or not the appellant's verified fourth amended complaint set forth sufficient allegations to state a cause of action. We brought 4 different counts in the fourth amended complaint. The first 2 are for implied warranties. Count 3 is for a negligence, and count 4 is for an express warranty through an assignment. The trial court provided little to hang their hat on here beyond saying that appellee's case law is more persuasive. I'd like to quote directly the court's basis for the ruling, which is, quote, "I tend to agree with the arguments Ms. Tolan is making today, and that enough time has gone by with the discovery that is there, and especially with the very in-depth case law that she has provided, that the motion should be granted." So
Can
in
I
this
interrupt you,
respect,
if I may, Mr. So maybe to try to
Please.
streamline it and get into the heart of the issue.
of course,
We all know, and I think there's no question that the court, we're dealing with that. You're correct, a de novo review based on the motion on judgment on the pleadings. And I think your position and Ms. Tolan's position is very clearly, you look at the pleadings, you don't go beyond the pleadings to make a determination whether or not, basic as a matter of law, that your client does not state a cause of action, or he's not entitled to the relief in which it granted. So having said this, I'm going to have you focus in one of the issues that I would like to hear your argument. The issue dealing with the implied warranty. We know the case law out there, and their big issue is to privity. Help me out. You're taking the position that you do not need to show privity in order for you to bring a claim under an applied warranty. Help me out and tell me the cases that you're relying on in supporting your position.
sure, Your Honor. First and foremost, we actually understand that there is direct contract privity is required under Florida law to state a cause of action for implied warranty. However, what we analyzed in both our initial brief and our reply brief are the numerous exceptions to that direct contract requirement. And we go through numerous cases, many of which were decided in 2020, which set forth the 2 recognized exceptions to the bright line privity rule under Florida case law, one of which is that Florida courts have found the privity requirement to be satisfied when a manufacturer directly provides a warranty or otherwise has direct contact with a buyer who purchases from a third party. So when you look at our fourth amended complaint, and really what we've alleged since the beginning, but specifically in the fourth amended complaint at issue, we go through a very detailed analysis and factual recollection of how a sales representative agent of FBR Marble came to our client, the owner of the company, and essentially gave them direct warranties about the fitness of the product and the reliability of the product, which induced our client to switch from his previous tile supplier or travertine paper supplier to FBR Marble. We cite 2 numerous cases from 2020 in the reply brief. We can begin here.
And if I may, Mr. Silverfield, help me out. The cases that you're referring to, at least in my reading of them, it seems to me those folks who are taking that position had, in fact, were the actual, for lack of a better word, they were the ones that have the damages. And in this case, your client is merely the distributor. So the cases that you provided with that are, these are people, the buyer, the actual buyer to a car, the actual, recipient to something. And where does your client fit in that scheme?
So that's a great question, Rana. I appreciate it. Actually, and this may be a fact question, but for the purposes of this argument, essentially the way that it works is FBR Marble provides materials to Pool Corp. They go under various names, SPC distributors, Horizon distributors. It's all the same company. They were a former defendant in this case, but only people like our client who sign an agreement with Pool Corp have access to purchase the materials. So a homeowner can't purchase the materials. Only our client can, because they are the ultimate purchaser through the middleman, which is Pool Corp. So that forms the basis of our count 4 as well, which is there was an express warranty between SCP, aka Pool Corp, and FBR Marble. And then there's a warranty between our client and Pool Corp. So in reality, the distributor is Pool Corp, our client is the buyer.
Mr. Silverfield, so on the issue of the middleman that you speak of being Pool Corp, in fact, isn't FBR also kind of a middleman? You mentioned the cases and talking about manufacturer. Are they in fact manufacturing? Or they're an importer of tiles, is that correct?
Yeah, yes, Your Honor. And I would say that manufacturer, distributor, supplier pretty much are all synonymous in this situation. And that's, I think, very clearly set forth in the Exhibit B attached to our complaint, which is the warranty between Pool Corp and FBR. It discusses, it says that all product furnished by FBR. So unless Pool Corp is buying something directly from the travertine quarry, we would state that it's a product furnished by FBR. And then again, whether or not natural stone can be something that's manufactured or supplied, we believe, again, is a fact question. But we have alleged sufficient allegations, we believe, to get past that. And at the end of the day, if summary judgment tells us otherwise, that's fine.
Don't many of the cases that you cite kind of deal more like with dealerships for automobiles, places where people are looking at somebody who manufactured and there's a middleman, as opposed to more of a stream of commerce argument where something's being passed along from one supplier to another, the end user? And the second question as part of that is then the Poolco was removed from that when they were settled. So how, in your analysis, does that affect this case?
Well, we don't believe that removing Pool Corp, settling with Pool Corp has any impact on the Fourth Amendment complaint because our causes of action are the same. In reality, if the court's inclined to say, okay, fine, because Pool Corp's, you settle with Pool Corp, they're no longer a middleman, that doesn't change the fact that we still have count 4 for express warranty through that assignment. I believe that in the situation that we're facing, the importer of the materials, right, who then gives it to Pool Corp, who we have an exclusive relationship of only being able to purchase those, is the ultimate manufacturer of sorts. And again, the fact that they have an express warranty with Pool Corp that specifically delineates any product furnished by FBR, I would assert that, again, this may be a factual question, but if it's brought into the stream of commerce by an importer, right, then they have a duty no different than Pool Corp does than we do to make sure that it's fit for being entered into the stream of commerce. And again, the issue that we're having is, in this case especially, and during the hearing as well, is that it's not like this is a motion to dismiss and there's not been anything that's been discussed. There's been depositions taken, there's been affidavits filed, summary judgment motions. The case has been going on for quite some time. So it's very difficult to remove the knowledge that we have through these certain fact questions from the way that we pled our Fourth Amendment complaint. But
Mr. Silverfield, so if I understand your argument correctly, you're distinguishing your case from those strict liability cases that apply where you have to have contractual, where you have to have privity in order to get to have a claim for implied warranty. And so if I understand you correctly, there's two situations and exceptions, I guess, as the cases have called them, which are the direct contact and the intended, the third party intended beneficiary. So if I could, I think I understand your direct contact is because of the special set of circumstances in the case here where your client was actually in direct contact with FBR and had those special dealings. And so I think some of the cases say these are exceptions to privity, or some of the cases say that this is more I think one case called it a relaxed privity based on the nature of that relationship. And so I think I understand the direct contact. The third party intended beneficiary, the FBR has said that you're barred by the statute, right? By 672-318.
correct.
And are you saying that this third party intended beneficiary cause of action is in common law? Because I'm trying to, Kramer, you've got Kramer, and so Kramer applied the situation and said, well, 672-318 is going to apply where the more appropriate cause of action is strict liability. And so in our case, we don't have those set of circumstances.
Correct.
So is this a common law claim?
Well, yes, in a sense that it was an additional basis for us to claim that we were could assert implied warranty. I think there's one specific sentence, one allegation in the entire Fourth Amendment complaint, which one could reasonably believe had anything to do with being a third party beneficiary. At the end of the day, I think the case law is such that it's either or. So we believe there would be both. If the court's not inclined to accept the argument of third party beneficiary under common law, then at the end of the day, I believe that the case law is clear that it's one or the other. It could be both. In this situation, we added that allegation simply to try to make our complaint I guess more cohesive and more.
Okay, in order to meet that third party intended beneficiary, under common law, I think the cases have said that it can't simply be generally somebody out there who's ultimately out in the public that eventually will have this product or purchase this product. And then it has to be someone very specific in mind, that, or someone that they specifically knew would. And so the facts here are that because of that, I guess, that contact and communication that FBR had with your client, you're saying then that that's the specific, that they were specifically intended? Is that the argument?
Yes, Your Honor, that's correct. Again, the localization of the area and the fact that the agent representative of FBR knew where they would be installed, knew that he was trying to expand. And again, are these fact questions? Maybe, but at the end of the day, FBR was looking to expand more into Florida in general. And our client had been working with another Florida-based supplier, and FBR was aware of where they would be installed, and they had a local representative who was aware of where they would be installed. and was aware that we would be
And if I
buying
may,
them.
Mr. Silverberg, we have to, I mean, now you're saying things that may be outside the record. Let's just
Yes,
stick,
Your Honor, I apologize.
let's just stick with that, sir. Thank
Okay.
you. Go ahead.
Yeah, and yes, and if you do look at our fourth amended complaint, we do state, and for the record, this is going to be on page, for the record, my apologies. Yes, 984. We discuss how FBR and our client's relationship was such that they knew where they would be installed. Yeah, essentially that this special relationship and the direct contacts they obviously specifically targeted our client to be to expand their business in Florida.
And if I may, Mr., you did not bring a claim for fraudulent inducement, correct? Because
No,
everything, all right, because fraudulent inducement, that will take it away from a lot of the requirements. And I just want to make sure that you were just proceeding with the implied, warranty argument. And just, you're approaching your 4-minute rebuttal. You could continue on if you wish to reserve the remaining of the time for rebuttal.
If there's further questions from the court, I'd be happy to entertain them.
I don't see any questions. All right, so I'll reserve you the remaining time for rebuttal. Thank you, sir. Okay, and I'm going to trouble you to please mute your microphone. And I think Ms. Tolan is unmuted and you're ready to proceed. All right, Ms. Tolan, please proceed.
Thank you, Your Honor. Good morning, Your Honors. My name is Jessica Tolan on behalf of the Appellee FBR Marble Incorporated. May it please the court. Within appellant's brief, there was essentially 3 issues raised on appeal. The first being the timeliness of the motion, the second concerning the claims themselves, and the third being whether appellant should have been entitled to leave to amend such that it could have filed a 5th amended complaint. Since today's focus in terms of the argument has been on the implied warranties, I will start with that to dive right into those issues. Florida law holds that a motion for judgment on the pleadings is appropriate where the complaint fails to state a cause of action, and it's similar to a motion to dismiss in that it raises only questions of law arising out of the pleadings. And in applying the standard, the lower court did correctly enter final judgment on the pleadings in this case as a matter of law because appellant's 4th amended verified complaint failed to state a cause of action, and that failure was evident by the face of the pleading itself. And so if we look at the implied warranty claims and what Florida law states is required for that claim to be sufficient, we see that there is a requirement of contractual privity between the parties. And in this particular instance, based on the allegations in the 4th amended complaint, there was no contractual privity, and appellant does not fall within an exception to this contractual privity requirement. And so I want to start first with the Kramer case, because I think it's important to start there and going through the analysis and seeing how the case law kind of evolved from there and how the courts are applying this law. And so what Kramer versus Piper Aircraft did was take the West versus Caterpillar Tractor Company case and clarify that an action for breach of implied warranties is a contract remedy. And as a contract remedy, contractual privity is required. Now, if a user were injured by a defective product, but there was no contractual privity, well, that's where we get to the strict liability in tort as a remedy in the alternative when there is no privity there. And so we see then the Florida cases start to apply Kramer in such a way that they do still require privity of contract. And we can see a couple cases coming out of this court, the first being Brophy versus Daimler Chrysler Corp. Now, it was brought under the Magnuson-Moss Warranty Act, so that may be a bit of a distinction. However, what this court has said, and other courts have also made the same statements, is that the Magnuson-Moss Warranty Act does not supersede state law privity requirements still, and specifically with respect to implied warranty claims. And so in the Brophy case, this court affirmed the dismissal of a breach of an implied warranty claim because the amended complaint did not allege the, quote, requisite privity of contract. We saw a similar decision being made in the Sirasani versus American Honda Motor Corporation. Again, a Magnuson Moss Warranty Act case, but still state law privity requirements would still come into play. This court also held that Sirasani's amended complaint does not allege that there was, quote, privity of contract between her and Honda, and therefore the claim for breach of implied warranty was properly dismissed at the lower level. And one of the other cases, which is a third DCA case, but it's Mesa versus BMW of North America. In many of the cases, even those relied upon by appellant at the federal level primarily, seem to quote Mesa as well. And what that court did was hold that Mesa could not maintain an action for breach of an implied warranty of merchantability, even where there was an express written manufacturer's warranty in that case. Because while BMW did issue an express written manufacturer's warranty, it issued the warranty to the buyer in that case, which was South Motors. And Mrs. Mesa's relationship was in direct privity with South Motors, not with BMW. And so the third DCA held that Mesa could not maintain a suit against BMW without that privity of contract. And if we apply the same logic that we see in these cases to the current case and the allegations that were pled in the fourth amended verified complaint, we see
Ms.
that.
Ms. Tolan, so how then do we reconcile cases like Cedars and ISK that talk about the direct contact?
Yes, sir. So Cedars actually came before Kramer. And so it raises an interesting question as to whether Cedars is still intended to be this exception that can be uniformly applied throughout implied warranty cases. But even if it were to still be considered good law applicable after Kramer, there are distinctions in Cedars that are not present in this case. And Your Honor's actually picked up on a few of the key distinctions within appellant's argument, which is that the chain of transactions in this case is that we have FBR alleged to be an importer and distributor itself, not a manufacturer, as we see in all of these cases. FBR supplies the travertine pavers to SCP distributors, and we can see this within the exhibits A and B to the complaint. SCP distributors, as far as from the terms and conditions of exhibit A, appears to be a subsidiary of Pool Corp. So whether SCP and Pool Corp are the same company or whether SCP then somehow got the goods to Pool Corp, the ultimate transaction was then between Pool Corp and Lefendos, and then Lefendos was still not the end user or consumer of the product, because then Lefendos installed the travertine pavers at customers' job sites or residences, as we also see in the fourth amended verified complaint. And so if we look at a case like Cedars, for example, in that case, the facts were that there was this hospital equipment that was not working. It was brand new equipment. The manufacturer couldn't fix it. And so it's a different type of product, whereas here we're dealing with a natural product. Again, you don't have that manufacturer component in the same way that these other cases have. And it also, like I said, it predates Kramer. And so then when you follow the line of cases that are applying Kramer, even federal courts like DeCerbo versus Melita, United States of America, was a middle district of Florida case, also relied upon heavily by appellant in its brief, that clarified that there can be no cause of action for breach of an implied warranty without privity of contract. And it was relying on Kramer in making that decision. And
but if we look at the opinion of Kramer, there's language in there that says that it abolished the breach of implied warranty where strict liability is appropriate. And I guess, it begs the question here where strict liability, we don't have that situation here. So how do you respond to that?
Yes, Your Honor. So without strict liability, without contractual privity, then Section 672.318 would provide a statutory exception for those not in privity of contract to where the warranty could be extended to a third-party beneficiary. However,
but that statute doesn't apply in our case here because we don't have that relationship between those parties here, correct?
Correct, Your Honor. And so without that relationship between the parties here, without direct privity between the parties, there is no claim for breach of implied warranties that would be sufficiently alleged in this case, which is why the lower court properly entered judgment on the pleadings as to the 2 implied warranty counts. The direct contacts exception, to the extent that is being applied by courts, is not uniformly applied. And one court has even suggested, and this is the Padilla.
Yeah, okay. Because Middle District has applied, I think the Middle District has applied it, right? The direct contact.
It has applied it primarily in the context of express warranties, which in a way makes sense because with express warranties, you can have affirmations or words of promise. However,
right, and we have a count here, right, with express warranties. So are you conceding that this would be applicable in that situation?
No, Your Honor, because the express warranty claim being pled here is an express warranty allegedly arising out of an assignment. And the assignment was allegedly based upon exhibits A and B to the complaint. And so if we look at what the allegations were, and particularly those exhibits, the allegation in the complaint was that exhibit A was the document within which allegedly, quote, all warranties between Pool Corp and FBR were assigned to appellant. And this would be at record page 985, and that's paragraph 23 of the 4th amended complaint. But what exhibit A actually is simply the credit or business application and agreement between appellant and Pool Corp. And Pool Corp is not FBR. And so there is no assignment language within that agreement as alleged. And then if we look to the actual terms and conditions within exhibit A, there is a waiver of warranties provision actually contained within the terms and conditions. So even if that exhibit A could somehow be deemed to have been an express warranty by FBR, which is refuted, and the exhibit I think contradicts that itself, this waiver of warranties provision would also contradict appellant's claim. And so when Rule 1.130 of the Florida Rules of Civil Procedure is clear that when exhibits to the complaint become part of the pleading for all purposes, and those exhibits then contradict the allegations in the complaint, the exhibits are deemed to control. And so the lower court also properly entered final judgment on the pleadings with respect to the express warranty claim in this case. And to address some of the other issues raised on appeal, I want to also briefly touch on the timeliness of the motion. One of the arguments that were made within appellant's brief was that the case was not, quote, at issue, and therefore the motion.
And if I may, Ms. Tolan, when a case is at issue, that's for purpose of setting it for trial.
Yes, Your Honor.
In this case, it's just a motion for judgment on the pleadings. It just appears, are the pleadings closed? And here clearly, there was an answer, there was a reply. So for me, at least from my view, you cannot, it shouldn't be confused with something's at issue. Something's issues only to set for trial. So in terms of the appropriateness of it going under that, at least in my judgment, I think that was appropriate. But let me go back because I asked that of Mr. Silverfield. He's taking in, I think, the positions that they were induced. They were induced to purchase all that, but they did not bring a claim for fraudulent inducement. By bringing a claim for fraudulent inducement, that would have taken away all these issues with privity, with warranty, anything like that. But they chose to proceed with the claim for implied warranty, express warranty, and then negligence. And then I want you to touch on previously of negligence because that has not been discussed yet.
Sure, Your Honor. Within the, regarding the negligence claim, appellant has argued within its brief that final judgment on the pleading should not have been entered because one, the lower court previously denied a motion to dismiss that was directed to a prior version of the complaint. And two, the lower court should have relied upon an attachment to a response to a prior motion to dismiss in making its determination as to whether to grant the motion with respect to that count. However, in looking at the allegations of the 4th amended complaint, we see that appellant was not the proper party to assert a claim for negligence, because appellant was not the party to whom the allegedly damaged property belonged, nor is it the party to whom the duty would have been allegedly owed based on the allegations in the complaint. Count 3 for negligence incorporates paragraphs 1 through 50 of the verified fourth amended complaint, of which paragraphs 29 through 30 and 35 through 37 specifically demonstrate that the travertine pavers at issue were installed at, quote, customers' projects, and any of the alleged unsightly growths were complained of, quote, by customers, and any treatments that were allegedly applied were at each, quote, customer's property and customers' pool decks. And so FBR denies any liability as to a negligence claim, but to the extent that one were to be deemed to exist, it would exist as a right of the individual customers to bring, and not one that Lefendo's could bring unless Lefendo's had demonstrated that it had an assignment, which it did not do with respect to the fourth amended complaint. And that's where Lefendo's focuses on the fact that there was a statement or an assignment attached to a prior response in opposition to a motion to dismiss a prior version of the complaint, but that does not make it incorporated into the fourth amended verified complaint. And so the lower court did properly enter final judgment on the pleadings with respect to that count, because it was not the party to whom a duty was owed. It was not the party that had the damaged property. And that is evident by the allegations in the fourth amended complaint itself. At a minimum, there would be a failure to join necessary and indispensable parties, which would be the homeowners / customers that own the property itself. In terms of amendment, and this was briefly touched on by appellant as well, in terms of should it have been permitted leave to amend the complaint. Well, with respect to counts 1, 2, and 4 of the verified fourth amended complaint, which pertain to the implied warranty and express warranty count, one amendment would be futile for all of the reasons that have been discussed with respect to the privity requirements and the exhibits to the complaint expressly contradicting the allegations themselves. However, there is also a failure in the sense that leave to amend was not requested by appellant with respect to those 3 counts, either in the response in opposition to the motion for judgment on the pleadings, nor at the hearing itself on the motion. Rather, the only count that amendment was requested of was the negligence claim. Again, I do not believe that amendment would be proper for that claim either, because Lefendo's is not the party that was allegedly damaged, nor the party that was owed a duty by FBR. However, if amendment were even considered, it would only be proper with respect to that count, because it would have been waived with respect to the other 3 and not preserved for appeal. At this time, if the court has any further questions, I would be happy to answer them.
Any questions? I don't believe so. Very good. Thank you, Ms. Tolan.
Thank you, Your Honors.
And I'm going to ask you to please mute your microphone. And Mr. Silverfield, you have your 4 minutes for rebuttal, sir. Okay,
thank you. With respect to whether or not the Middle District recognizes the direct contracts exception, in Dallas versus Boston Psycorp, the court states that the interest of privity in order to recover damages from the sale of a product for breach of express or implied warranties under Florida law are satisfied by direct contact. And then also in...
And if I may, Mr. Silver, because I looked at the cases, and one of the things that you look like Atlantic Specialty, which is from the Middle District. And yes, it indicates that, but if you look at the parties themselves, wasn't in that case, the actual person who brought in suit was a subrogee of the actual injured, for lack of a better word, injured, person. So there was almost that direct impact. And what I'm struggling with in this case, we're dealing with a distributor, we're dealing with an importer, we're dealing with the chain, and we're not dealing, I mean, it will be one thing if the actual customer, the person who has the pool and, bringing a claim, that would be a different scenario, but we're not dealing with that. And so the cases regarding direct contact and so forth, that deals more directly with the, lack of better word, the injured party. Help me out with that.
Okay, well, first of all, again, Your Honor, there's multiple other cases that I cited in my reply brief that I believe are more applicable than those. You have Toka versus Tuco, you have Fuller versus Miramax, Kendall versus Boston Side Corp, Peoples versus Omega Flex. Those are more in a manufacturer, middleman, distributor situation, as opposed to the Atlantic Specialty case. I do agree in that respect. However, again, at the end of the day, if we had to plead in our amended complaint, fifth amended complaint, that we can't, then the homeowners can't purchase things directly from Pool Corp or SCP, then that's something that we believe makes amendment not futile. Because at the end of the day, that's the issue, is that nobody can purchase, a homeowner can't purchase materials directly from FBR. A homeowner has the credit agreement that's attached to the Fourth Amendment complaint is what allows anybody to purchase something from Pool Corp. And again, I would also like to point to the fact that if you look at this agreement, Ms. Tolan stated that it's between Pool Corp and our client and not FBR, but actually it does state here that it's actually Pool Corporation and its subsidiaries without limitation SCP distributors. I would also like to point to the language in this document that Ms. Tolan said that there's no warranty language. It does state goods sold by SCP are warranted and guaranteed only by the original manufacturer of such goods to the extent and manner warranted and guaranteed by the manufacturer. So again, whether or not something constitutes an assignment language is between us and SCP Pool Corp, not between us and FBR Marble. We alleged that it was. We attached both warranties, and we quoted both warranties in our Fourth Amendment complaint. With respect to the negligence count, briefly.
And very briefly, Mr. Silver.
Yes, Your Honor, I apologize. The reason why we didn't attach the assignment to the Fourth Amendment complaint was because the court determined that we didn't need to attach it. We can't be denied the ability to amend to attach the assignment based on the court saying that you didn't need to attach the assignment, only to, a couple of months later state under the same circumstances and the same standard of review that you did need to attach it. So we never were given the opportunity to attach it because we repled what the court said stated a cause of action even without the assignment.
Very good, sir, because you've actually gone over your rebuttal time.
Sorry.
I appreciate you both, well argued on both sides. So at this time, I'm going to ask you to please exit while we bring in the other group. Thank you both.
Thank you, Your Honors.
Thank you, Your Honors.